intended for informational purposes only. The information does not constitute legal advice. The law constantly changes, and the information may not be complete or correct depending on the date and your particular legal problem. Each legal problem depends on its individual facts. Different jurisdictions have different laws and regulations. Because of that, you should not act or rely on any of the information in this segment without seeking the advice of a competent attorney licensed to practice law in your jurisdiction for your particular problem. We have one of those fellas on the line with us right now, as a matter of fact. He is Marshall Chriswell. Good morning.
Good morning, Todd.
Good to have you with us on this beautiful Monday.
Nice to be here.
Now, it's not the most pleasant of topics, but everybody has to deal with it at some time or another. A loved one dies, and we're not pros at this. We don't know what we should do. With no experience in this field at all, what does someone do? What are the procedures and the steps that people need to go through when someone close to them dies and they're responsible?
Sure. So particularly, let's talk about the process of opening an estate. And that's a term that you hear, and everybody maybe is familiar with that, opening an estate or opening probate, and it's kind of a scary term, and a lot of people want to avoid it and don't really understand what it is. So let's just talk about that a little bit. So a probate estate is going to be required basically anytime someone passes away and they own something in their own name. Okay. So when I say in their own name, I mean not jointly held with survivorship, and not an investment or retirement account or life insurance that has a beneficiary designation on it. We're talking about things you own in your own name, whether it be real estate or bank accounts or personal property, things like that. So someone dies and they own stuff. Generally, you need to open a probate estate, and what that means is that an attorney is going to prepare a petition, and it's called a petition for grant of letters, and that petition is going to be presented to the Register of Wills in the county, generally the county where the person resided when they passed away. There are some exceptions to that, but that's by and large the general rule. You're going to present it to the Register of Wills. And it's going to be presented at a time when the person who's being appointed as the executor or administrator of the estate, so the person named in the will is the executor or the person applying to be the administrator if there's no will, they're actually going to be there physically and be sworn in to handle the administration of the estate and ensure that they follow Pennsylvania law in doing that.
Mm-hmm. Mm-hmm. I should have phrased it a little bit better than I did. I said when somebody dies and you're responsible. I meant you're the responsible party for disposing of their estate.
Yeah, right.
I recently conducted a funeral, and after the service, a gentleman came up to me who was the lone surviving member of the family of this elderly woman who had passed away, and he said to me, "What do I do next?" And I said, I'm really not the person to ask that question of. This is where an attorney is really the guiding hand that you need, isn't it?
You do, and the process of administering an estate when someone passes away is extraordinarily complex. The law is complex. The law is counterintuitive in a lot of ways. And I can't tell you how many times I've had someone come into my office with a stack of papers and some things, some forms that they've kind of half filled out, and they sit down and they say, I lost, my mom, my dad, my spouse, whoever it is, and I wanted to do this process, and I wanted to do it on my own, but I just can't. And so, can you handle this for me? It's a difficult, and you're already dealing with so much right then, as far as losing someone. And then there are all these steps that you have to take to ensure that, that you do it the legal way and that assets are protected and that creditors get their fair shake out of the estate and things like that. And so it's difficult, yes.
All right, so let's start with some of the basics. And the first thing I want to ask about is timeliness. Are there schedules that have to be met?
So there is not a deadline for opening an estate. I've opened estates 20 years after someone passed, because there was some asset that became discovered that you had to. It required the opening of an estate. So there is not a time frame on opening the estate. The only real deadline that we're dealing with in estates is if there's going to be inheritance tax owed. Generally, the Pennsylvania inheritance tax filing deadline is 9 months from the date that the person passes away. So that's really the one deadline that we're dealing with.
Some of the burdens of that person who has passed away, though, do get passed to whoever comes next. And I'm thinking property taxes here. There certainly need to be systems put in place there, do they not?
Absolutely. Now, I say there is no deadline. You want to get the process started as quickly as possible if there are probate assets, so that administrative expenses can be paid, and proper accounting done of that, and so that we can declare deductions on the inheritance tax return, and that you're moving along the administration in a timely process. Also, if there are creditors, if the person owed, a mortgage, or had medical bills, or had long-term care, or other debts and things, those are going to need to get paid, and tax collector, as you mentioned, those folks are going to want to get paid. So it is important to move it along in a timely manner.
Okay. So what are the steps that we should take beyond that first step of calling an attorney or setting up a consultation? So
once we've done that, and once we've prepared a petition, the next step then, as I said, is to get it filed with the court and have the person sworn in as the executor or administrator of the estate. Now, I use those two terms, executor and administrator. If the person had a will, generally that will name someone or multiple people as executor or co-executors. If the person didn't have a will, or had a will where the executor isn't named, or the named person is deceased or unavailable for some reason, then we're filing a petition for letters of administration and having an administrator sworn in. And there are, some kind of issues that can arise with that, and sometimes these things can be alleviated a little bit by some proper planning. One of the things that I run into quite often is that someone did a will, and maybe they did it themselves, and either they didn't have anybody witness the will, because in Pennsylvania you can have a valid will without any witnesses. So they didn't have anyone witness the will, or they have witnesses, but those witnesses are that their signatures were not notarized, and there's no affidavit of witnesses attached to the will. So first of all, you've got to look at this will and say, okay, is this a valid will under Pennsylvania law, and what kinds of issues are we going to run into here when we try to probate it? So you need to have the original will. Can't probate a copy, and you got to have those witness signatures with the affidavits. And if you don't, so if someone signs a will, there's no witnesses. Whenever we probate it, we've also, in addition to the executor, we've got to find two people that can swear under oath that it's the deceased person's signature on that will. Mm. Okay, so you've got to bring these folks in as well. Or if it has witnesses and they're not notarized, you've got to find the people that witnessed it and bring them in. So that's some proper planning by the person drafting the will, and making sure that those things are all done correctly. So that's one of the issues that you run into.
Okay. One of the things that I find interesting is that it seems that many of these conversations we have, you and I, when we're talking about this, come down to while you're healthy, or while you can, when you can, really planning ahead of time and getting everybody who's going to be involved in your end-of-life issues up to speed. And I would assume that the attorney would be a key in setting that up as well.
Absolutely. If you, I find that I help people a lot when they've had some planning done in the past, and they want to take another look at it. This have been done 10, 20, 30 years ago, and we take a look at the documents they have. There are almost always changes that need to be made, updates with respect to new laws and things like that. They may need to change executors, and they might be looking to change who the beneficiaries are. But you're absolutely right. It's so important to look at that and to talk to the people that are involved, make sure that everyone's on the same page, and make sure that those documents are very clear and that they're going to be understood and interpreted very clearly by the Register of Wills when you're filing this will eventually for probate, and by all the parties involved, so everybody knows what your intentions are.
You don't want to saddle somebody with something that is a boondoggle right from the start. You can take care of that by handling all of this stuff beforehand, can't you?
Sure. So, you have the classic example of the married couple that comes in, they have 3 children, and they say, okay, we want to name all 3 kids as co-executors. Okay, fine. You can do that. There's no problem with doing that. But let me explain to you what the pitfalls are, right? How well do all of these children get along? Where do they live? Are they scattered out across the country? How responsive are they going to be to requests for signatures and paperwork and scheduling meetings and phone calls? A lot of times you have that conversation, and eventually you come around to the fact that, okay, well, yeah, we're naming all 3, but really our understanding is, or from this married couple's point of view, their belief is, okay, our oldest daughter really is the best person here. We're naming all 3 so we don't upset anybody, but we know our oldest daughter is going to take care of everything. Okay, well, in that case, let's just name your oldest daughter as executor, because if you try to do this and not ruffle any feathers, really you're creating more of a problem for everyone, because the other 2 are going to have to either sign off and allow the oldest daughter to serve. They're going to have to sign what's called renunciations before we can probate the will. Or they're all 3 going to be appointed together, and they're going to have a heck of a time working together for whatever reason, whether it's personalities or geography. So let's have that conversation and do the right thing now, so that we're not dealing with issues later.
Good planning is always a good idea. Marshall, if somebody wants to start that process with you, what do they need to do?
You can always call my office, 724-465-5826. Stop and see us in the R&P building at 655 Church Street in Indiana, Pennsylvania, or go online to www.westernpalawyer.com.
He is Marshall Chriswell. Thanks so much.
Okay, thanks. Take care.
Bye now. It is the voice of Indiana County, WCCS 101.1 FM and AM 1160.